disruption, we thought that would be the best way to go about doing things versus someone sitting behind bars. And we are a society that truly know that jail is not really a deterrent, but if there's someone that I think somewhere in here it doesn't, it talks about, subsequent offenses. We wouldn't expect someone that's going to continue to do the same thing over again to be afforded this opportunity. This is more opportunity for someone that hasn't offended um, over and over again or whatever, and that allow them to be with their caretakers, because there's a disruption all around in terms of whether it's your children or someone that you're caring for. So that's the essence of it.
Thank you. Any members of the public that want to speak? Oh, I'm sorry, Representative
Oh,
Murphy.
that's okay. Thank you. Um, I have very mixed feelings about this bill. In theory, I think it's a great idea. I absolutely believe that we should be doing whatever we can to minimize incarceration. For all the reasons that we know, there are challenges around that. My concern, as a former employee of the state's child protection system, um, are around the ACEs not only involve violent crimes, but there are other impacts to children, and the vulnerable populations, maybe the disabled community, that I don't know that are necessarily protected by this. One of the things that I noticed, I don't think when we're talking about primary caregiver, um, we're not talking about sometimes a custody. I mean, I don't think that's necessarily addressed here, whether or not that person has custody. Um, and I don't know. I feel like it needs a little work, and I don't know, given the input that we had from some of the stakeholders. It specifically, at least as it stands right now, I understand it doesn't address if the vulnerable person is the victim. And that my understanding also was that the judicial system already has the ability to impose lesser sentences, and I having worked in the system and with some parents that was struggling with substance abuse challenges, I absolutely agree. Somebody testified that even though they have the ability, sometimes there's bias, and I wholeheartedly acknowledge that, and I think that's a reality. But I'm not. I'd be interested in seeing if there are things that we could do to address those concerns, because as is, I don't know that. I think we have to be conscious of balancing the rights and the protections and the well-being of the vulnerable, disabled, and children, with doing the right thing for parents who need help.
Thank you. So there was a Senate bill last year, I believe, SB 254, that is similar to some of this bill, almost verbatim. I think the new bill, obviously, there was quite a bit added to it, probably to maybe answer some of the concerns the Senate had with it. It was killed in the Senate. My opinion is it may have made it worse. I think there are some things in it that might be confusing. It might actually open the door for judges sending people back into the homes to re-victimize. That's my concern. I think at this point, it probably needs a lot of work and a lot of amendments to make it workable for where all parties are happy with it. But I'm willing to listen to any other testimony about it. If anyone from the public wants to speak on what your concerns were. I may have a question for Attorney Enders, just so I can refresh my memory on something you may have testified for last time. And I don't know. I agree that the bill has some merit. I just think it needs a lot of work, and I think it's going to cause more damage than it is good. So I guess a question I have is, was it this bill that you spoke that the nine county attorneys and you were all on board with it? Was it this bill?
No.
Okay,
No.
that's what I wanted to clarify. Okay, so anything that you tell us or you told us in testimony was yours.
No, I would indicate that, again, in New Hampshire, everyone obtains an individualized sentence. One of the things I would draw the committee's attention to is RSA 651 4B. And that statute is entitled Pre-Sentence Investigation of Members of and Veterans of the Armed Forces. It essentially says when a defendant appears in court and is convicted of a crime, the court shall inquire whether the defendant is currently serving in or is a veteran of the armed forces. And then it goes on to say if the defendant is currently serving in the armed forces or is a veteran and has been diagnosed with having a mental illness by a qualified psychiatrist, the court may, and it goes on, but essentially says, consider the treatment recommendations of any diagnosing or treating mental health professionals together with the treatment options available to the defendant in imposing sentence. And I think that's the gist of what this bill wants to accomplish for caregivers, not necessarily veterans. And I think almost less words might be more, in the sense of saying the court can take into consideration an individual's status as a caregiver prior to imposing sentence. And again, I think the court can do that now, but I think maybe making it more explicit would be what the drafters are looking for, and at least to let the court know that. And again, everyone in New Hampshire gets an individualized sentence, and it's certainly welcome anybody to come over to Superior Court and watch sentencing. They're public hearings, and you can certainly see what the court talks about and goes through when making those sentencing decisions.
Okay. So would it be your opinion that what this bill is trying to accomplish is already being done or can be done with the existing legislation?
I would say it's already being done on a daily basis. That I know certainly as a prosecutor negotiating sentences with defense counsel, if someone is a parent or a caregiver, that's almost always brought to my attention. That because defense is using that as a mitigating factor to say, please don't send this person to jail because they have kids, they have a job, they have an apartment, they have, people they're taking care of. Whether that argument wins the day or not is a separate issue. Certainly it's something that is taken into consideration.
And in your opinion, is that basically the essence of this bill, is just allowing, I guess, a judge in this case to consider those things, not necessarily rule that way?
That's how I read this bill. There is a list of specific treatment or options in A to J of what the judge can potentially impose. Really, a lot of those options are available in every case to the extent they're available at all. And I say to the extent they're available at all in the sense of, I think it's difficult to find some of these programs because they're not state run, they're not funded programs.
You had a question about constitutionality, I guess, of sentencing without knowing what the sentence is going to be, that vagueness.
Yes, I had those concerns with respect to paragraph 3. I think there's a way it can be done that's constitutional, and I don't want to be misunderstood that I think this is a complete dead end. I think it just needs a little tweak with the wording, essentially that the court can, suspend sentences, require people to appear for future review hearings, and can impose the sentence at those hearings.
Thank you. Anyone have questions? Representative Newman?
Yeah, my question is, I agree that this bill has merit, but I also think that there are too many lists. I think they try to cover everything, and when you get a list, invariably you leave something out, and then they try to define, or it appears that the bill is trying to define what a judge can and cannot do. So now you've put handcuffs on the judge, and you may not have put in things that he should be able to do but can't do because now they're confined to whatever is in the list. So
Yeah.
I would have difficulty supporting the current wording of this bill.
Well,
And I don't, if you have a comment on that, thank you.
and just to follow up on that, I also, one of the things that we have difficulty with is you'll have a judge who will look at this and say, well, it says I can provide drug and alcohol treatment for a person who's a caregiver, and they may interpret that to mean I can't provide drug and alcohol treatment to a person who's not a caregiver because it's not explicitly given to them. So I do think you run a potentially a concern with that as well.
Representative Murphy?
Thank you. Yeah, the carve-outs was one of the issues that I had concerns about. Just in an attempt to ensure that certain things were left out, I just worry that some that may be equally important are not considered. I really like the idea of this bill, and I agree that it has great merit. When I was listening to the testimony and reading the specifics of the language, to me, this is a bill that is such a great reminder to us of we need to invest, we need to fund programs so that we allow the courts to have options. I mean, it's one thing to say, we want to send somebody to whatever treatment, but if there's no spots to put that person in, we're doing a disservice to the individual. We're not meeting the family's needs. We're not, then the consideration of the impact of ACEs on the children of incarcerated parents aren't really being weighted properly. So I think this is just a real lightning kind of call to say, hey, we've got to fund programs to give the judiciary options, and address things like all the precursors to the challenges that these individuals are winding up on, whether it's mental health, substance abuse, and we want to, in a number of situations, just in my history with the division, I was the nurse. I wasn't a child protection service worker, but the children that we're talking about very often had adverse childhood experiences unrelated to the criminal issues that we're addressing here. And we need to be able to do something about that too. So it's a huge issue. I like the idea, I like the intent. I'm just, if the thought is that the ability for the court system to already do this exists, then we don't need to, re-legislate that. But I would certainly love it if we could, training for judges as to, hey, please make this your first consideration, and then whatever, and use this, this goal as a way to drive forward, options for. I mean, it meets so many needs. It meets the needs of the children, meets the needs of the parents. It meets the needs of the courts, the prisons, and so, I don't know. That's just some of my thoughts.
Yeah, I mean,
Thank you for letting me come up. I'm Paul Halverson, County Attorney for Merrimack County. I'd like to elaborate on a couple things Attorney Endress mentioned, in no particular order. Pre-sentence investigations. Many people don't know, but I was a defense attorney before I became a prosecutor back in the early 2000s. And they routinely did pre-sentence investigations on felony offenses back in the early part of the 2000s. They were quite helpful at times because they delve into issues such as those raised within this statute. Probably close to, I'm willing to bet about 10 years ago or so, the PSIs started getting used less and less and less and less, to the point now where I think they're the virtual, the rarity is a pre-sentence investigation, although it's still allowed by statute. And I think that's an important tool, but along those lines, I don't think that the Department of Corrections is at the same staffing levels that may allow them to complete those. So it comes back to a funding of a program issue to get the information in front of a judge. There are some specialty programs throughout in Merrimack County as well as in other counties. For misdemeanor issues, Merrimack County has a mental health court, but it's only at the circuit court in Concord. Rockingham County has a veterans court in the felony world where we can refer people, we can transfer a case with a negotiated disposition over to Rockingham and get it into the veterans court. And that veterans court has access to housing, VA medical care issues, counselors for individuals, a whole laundry list of available programs, but it's one location. And it all comes down to funding of those individual programs. Merrimack County House of Corrections has a whole list of programs that are available for people that are incarcerated, as well as those that are under supervision within the county. They talk everything from case management, religious, substance abuse, mental health, medical assisted treatment for drug use, electronic monitoring, anger management, addictive thinking programs, Narcotics Anonymous, Alcohol Anonymous, work release programs. Those are all available, but those are all, again, driven by funding. And we're lucky in Merrimack County, we have a pretty robust system for that within the House of Corrections here. But again, those only address misdemeanor or House of Corrections sentences.
Thank you. Representative Bolden?
I hope I understand correctly that the format in a subcommittee is that I don't necessarily need to be asking questions of witnesses and that this is a conversation between the committee members. On that note, when we were working on this language, which we did spend quite some time on, I was under the impression, and I think the other stakeholders were under the impression, that the Tennessee language that we modeled this on was complex. And I distinctly remember looking it up, reading it, working to model our language off of that, but make it more appropriate, realistic. And so I went to look that up in preparation for this hearing and realized that somehow it became one sentence. And that sentence that was added to Tennessee law, and I'm not sure when this happened. I don't know if they passed that complex version, because I don't know how to use their website necessarily, but it just says available community-based alternatives to confinement and the benefits that imposing such alternatives may provide to the community should be considered when the offense is nonviolent and the defendant is the primary caregiver of a dependent child. And I think they were saying that it's probably too specific, should be more broad. I do think that as a general rule, broad is better than specific. I definitely worked with the stakeholders to make it less specific than they were asking. But I'm just sharing that. I feel like that could be an alternative version of this bill, but I was also thinking of just handing you, I asked our committee researcher to give us all copies of this, but instead he put one copy in my folder, in my filing cabinet that I haven't looked at in like a year. So I just realized it was in there, but if I gave this to you, maybe you could consider how you think it fits into the mold of how things work right now.
And I think this dovetails into what I had said earlier with reference to 651-4B with reference to veterans, is broader may be better, just to say the court can certainly take into consideration whether or not a person is the primary caregiver of a dependent child in a nonviolent offense.
And that should be an inclusive list, not an exclusive list. To allow that to be an inclusive list among other factors that a court ought to consider, not an exclusive list of one.
Thank you. And again, I just come back to this question of, if it's already the policy and it's already in law and it's already being done, what's the point of making another law? Just to reinforce that? I guess that's my question. Representative Bolden?
I think that there may be a practical, but I'm not an attorney, so maybe they have a different perspective. But I think there may be a practical difference between directives that a judge is aware they should be considering during, the criminal justice process versus an argument that a hired attorney available only to certain people with certain funds would know that they could successfully make based on their experience in work, their knowledge of the judge, their knowledge of case history. I think that that's, you know what I'm saying? I feel like that's the difference, is that if we make it clear that this is acceptable, perhaps it would be considered more frequently and applied to the folks that we're trying to target, which are the folks that, while under the law should be facing incarceration, aren't a threat to the public and have dependents who would be adversely affected by their incarceration.
But I think it was testified to that it's already in law, that this is to be considered that way. So we'll be making a new law just to reiterate what another law says. Am I wrong?
There's nothing currently explicitly in the law saying that the court has to consider whether a person is a caregiver for a dependent child. But certainly the court can consider that under current law, and I think would consider that under current law if it was brought to the court's attention. And just to follow up, we had talked about people facing incarceration. At least in New Hampshire, the Constitution guarantees everyone who's facing potential incarceration the right to an attorney. So if they can't afford one, they'll be appointed one through the New Hampshire Public Defender's Office. And as I'm sure you're aware, the New Hampshire Public Defender's Office is the largest law firm in the state of New Hampshire, and it has very talented, dedicated attorneys working there.
I've worked with some of them. Representative Wheeler, did you want to speak on this bill? Yes.
Mr. Chairman, I just wanted to say that I definitely respect all the, there's some nuance that needs to be met here when it comes to this bill, but I do just think, based on the fact that this isn't currently in law, that despite the fact that I respect that the judges are probably good people, and a lot of them probably do take this into account, especially in Merrimack County, just because we got this guy here right now. But I do think that there's a concern that exists from people that have gone through the court system right now, that some of those judges, because of not any necessary, we can get into the biases in another place, but because of the history that people have, are sort of just getting these cases and then sending them through without consideration. And I think having something in law that makes sure that there is that consideration, that the judge says to themselves, okay, I have to listen to RSA 6 whatever, because I have to make sure that there's due consideration here for somebody who might be a primary caregiver or something like that for someone else. So that would be the only thing that I have to say to that.
Representative Bolden?
Thanks again. In response to the note that was made about the right to an attorney, I think it's worth taking into consideration that there are many cases, I would say a large majority of cases, that never go to trial. There's a plea deal. And I'm sure that if we could obtain any statistics on the reasoning used in accepting a plea deal that's offered, that the ability, that the impact of the length of incarceration on their lives or the lives of dependents would be a factor for the person deciding whether or not to accept a plea deal. Like, if I take this to court, I'm going to be in jail pre-trial for God knows how long. I could lose my kids, but my mom can take them for 3 months if I just do 3 months and I plea this out. And that's the kind of situation that comes to mind when we're talking about making sure that judges, whether they're reviewing what kind of sentence to apply in something that went to trial, where someone had an attorney, whether they paid or whether it was a public defender, but as well as situations where someone's taking a plea deal, they're going to end up in front of a judge regardless. The judge is going to ask them, do you understand what you're pleading to, etc. And so in those situations where someone might be, especially because someone who's taking something to trial is either, I would imagine, extremely confident of their innocence, or is it moneyed in a situation, you know, to the extent that they're able to challenge that. And I'm not talking about people that are innocent. I'm talking about people with this bill that are guilty, that are under the law deserving of incarceration. And that, so the odds that they're going to end up obtaining a public defender and taking it to trial, I think, are incredibly small for the group of people that are targeted by this legislation. And so the idea is that when they go through that sentencing process, for a flag to pop up and say to the judge, the legislature, which has authorized the courts to exist, agrees and supports the judge if they want to assess some kind of sentence that doesn't involve incarceration because of the outlays of the people affected by that person being incarcerated. You know, because like in that example, my mom can take the kids for 3 months, but that's it. Those types of situations, I think there should be a conversation. It should be taken into consideration. We don't want kids going through the system. We don't want kids with trauma that are going to end up being repeat offenders when they're adults. We don't want more people relying upon government benefits that are necessary. And, you know, it just seems like a fiscally responsible choice that if a judge definitely agrees that someone can be reformed without incarceration, that we go that route, because there's just massive expenses around incarceration, not just to house and feed someone who's being incarcerated, but then to deal with the people that they're no longer able to care for. So if there are people in this state who are guilty of crimes and who can be reformed without incarceration, we should be looking at that regardless of however we get there. I'm cool with that. But I feel like this paragraph in Tennessee law might seal the deal.
Representative Stone.
Thank you. As a individual, not a member of this committee, I'd like to state that-
Individual Stone.
individual Stone. I'd like to say that I would assume, in my experience, which was 25 years roughly, most judges understand judiciary discretion when it comes to sentencing, and most of these cases are pled out, and they are represented by attorneys at both the misdemeanor and felony level. And a good majority, I would say, probably 95% or more are plea deals versus actual trials. And the representation from the public defenders or a private attorney who operates in the best interest of the client to bring these mitigating circumstances to the table when it does come to incarceration. I think the sentencing guidelines do exist for a reason. And I just can't imagine a judge going off the reservation, as you will, to say that I have seen judges refuse to accept plea deals, but it's very, very seldom in my experience. I don't know if Attorney Enders could elaborate on that, but very rarely I think you do see judges that just flat out receive the plea deal between both parties.
Thank you. Let me point out, within 651(2) in the annotated statute, there's a section of footnotes under section 4. It talks about the discretion of the court. And one of the footnotes says, this section, referring to the sentencing section of the statute, demonstrates a continuing intent by the legislature to provide the sentencing judge with options to adapt his or her sentence to a particular individual in a manner best suited to accomplish the constitutional objectives of punishment, rehabilitation, and deterrence, and it refers to an individual case. In 2022, there was another case, most recent one, it looks like, that is cited in the notes, and it says, trial judges have broad authority under this section to provide for extended terms of imprisonment, a range of fines, probation, and conditional or unconditional discharge. And it refers to a 2022 case. So the courts have acknowledged that they understand their sentencing flexibility, and that's been repeated throughout many of the footnotes. And I don't know if the committee has access to those footnotes, but I can certainly provide those after the hearing.
And that specifically says that's the intent of the legislation. So the judges know that that's what our intent is.
I'd have to look at the actual case. This is an extract from the case, but the extract is clear that this section referring to 651(2), which is entitled Sentences and Limitations. And it clearly says within the parameters this section demonstrates a continuing intent by the legislature to provide the sentencing judge. It goes on from there.
Thank you. Representative Murphy?
Thank you. I was wondering, could you read that, was it, what state was it? The little blurb that you have that was
Tennessee.
proposed? Could you read that again? It was one-
Available community-based alternatives to confinement and the benefits that imposing such alternatives may provide to the community should be considered when the offense is nonviolent and the defendant is the primary caregiver of a dependent child.
Thank you. Would you understand that to mean not just the community, but to the dependent child or the whatever disabled adult or an elderly parent? Is it just considering the the community, or are we also considering the best interests of the child?
I read that to mean both.
Okay.
That if there is a suitable community-based alternative to confinement, that would benefit both the primary caregiver and the dependent child, then the court should consider that.
Thank you.
Anyone else in the public want to speak on this bill? If you have anything to add more, I guess your position's still the same on it? You can come on up. Yeah.
And feel free to join me if you want. But I think a group of us met this morning, specifically focusing on the child protection component. I do think, our position on this has been pretty unwavering, just because it's been hard for us to picture what an easy fix to this legislation would be. We agree that there's merit and this is something that should be explored. But I think even just the term nonviolent in that, I think that language is so close, but just knowing the complexities that we've had in addressing, what does it mean to actually be a violent crime when it could actually be a harmful act? Like lewdness and indecent exposure isn't considered a violent crime. Is there a physical injury component of it, and that's what makes it a violent crime? Then that would leave out a lot of things. So I think if there's an opportunity to continue to explore this, to look at how this could fit in. And I also just wanted to echo the funding component of it to make sure that the adequate resources and services are there so that we really are setting folks up for success. I think just wanted to echo those things. So I think in brief, yes, our position is the same, but we're happy to continue to have these conversations. Sorry.
Oh, no. And like Pam was saying, we did meet this morning and we are very open to discussing how we can work together and figure out how we can make this bill a more better suit and fit to make sure we support them and what they feel that this bill can be better. So having conversations like we did this morning, having a subcommittee and speaking with you guys would be really good. So yeah, absolutely.
Yeah. Okay. I'm just going to say that when we heard this bill in our hearing, one of the things that I asked is that we come together to see how we can get this bill in a passable, and Attorney Andres and Pam and I believe it was Grace at the time, I thought would come together to figure some of this out. That whole laundry list that's here, and for me, I would have preferred that it just said nonviolent. And this is our violent crime for the state of New Hampshire. It tells you all the difference. So I think carving it out probably wouldn't work for us because we're leaving something out. And the other on children, I like that idea. But I do believe this bill has a lot of merit. I truly believe that. And even when we list like the drug and alcohol treatment, anger management, I don't think we even need to do that. I just believe that there's so many different services out there. Some are citywide or based on where you live. I know Merrimack County seems to have a lot going on. That's great. Hillsborough County, which is where I live, we have a lot going on, but not enough. But we do have different organizations, like take Nashua, that actually everything that's listed here, there is someone or somewhere that you could refer. So for me to have a bill like this, I think it's great. I think it also keeps in mind with the court system that these things are here, and people really do have a problem, but we can help them to solve their problems, as long as it's not violent or something that affected a child or all the things that Pam just named. I don't think it's that. When I listen to some of you speak, I feel like, what's so difficult about this bill? And I just don't see it. I really don't see the difficulty that folks are having with making certain changes.
I think it's because there's a lot of changes in there, and a lot of them have some adverse effects, whether it's unknowingly or not. But I think might be too big, too wordy. But it doesn't. But at the same time, doesn't include a lot of stuff. So, Representative Bolden.
In crafting the language, we did, the stakeholders who participated in crafting the language, many were invited, but those who participated, we discussed whether or not the options that that a judge could assign would be attainable. And I think it's worth noting that, like with therapy, for example, the criminal court isn't the only court where you could be ordered to go to therapy. It definitely happens in the family court system as far as estranged parent-child relationship, maybe someone who has anger issues as it relates to their family. So it's not the first time, and I'm not just spitballing, like I unfortunately know firsthand that I wasn't assigned anything, but it is possible for a judge to say, you have to go to therapy. And when demands like that are made, we do already have systems in place in the state to make sure that that's attainable, such as expanded Medicaid. There is a wide variety of mental health providers in the state. And I certainly, in my own life, have never had trouble finding one that accepted my insurance. And I've certainly recommended it to lots and lots of people because I do think therapy is a really good choice in life. And I haven't really observed other people having difficulty. If you have a really obscure insurance provider or a bad plan, it may be financially limiting, but that'd be something that the court would need to take into consideration. And so as far as the availability of services, they don't need to be publicly provided. They don't need to be publicly funded. They don't need to be coming from a program, the way that the bill is worded. It's just, you need to do these things to take care of your life, to work on improving yourself so that you're not going to be in front of a judge in trouble for something else.
Anyone else have anything to add?
Yeah, I have a question. When you guys met this morning, okay, did you come up with anything?
So there was the Office of the Child Advocate, Waypoint, ourselves, and then Ms. Burnett and Ms. Kandecki, and then did I miss anyone?
And Amanda.
Oh, and Rep. Bolden. And I think we were all in the same quandary. We all expressed again that this has merit, but none of us had a direct recommendation. I know the question was posed, well, what is the population that's trying to be served here? And do we start with a list of crimes that that are specific, or do we look at modeling something off of or attaching something to drug court and mental health court? I think it's just a question of where we can start, maybe from a pilot, and then go from there. But there was no one had an easy fix to this bill that would satisfy all of the concerns that have been brought up, especially from a child protection angle, because there's just too many opportunities, I think, forget something when we're rushing to move forward on a proposal, when there's just a lot that really needs to be considered. So I think that's kind of where we were coming from that lens. I think if we had a solution, we would have proposed it months ago. But I mean, and that's kind of why the bill last session, I don't think was able to move forward either. Because I think it just we need to look at this in a very different way.
Also, some of the things that we talked about was maybe instead of having a long list of things that you couldn't be eligible for this bill, or maybe coming up with things that you would be eligible for. Also, another thing that I brought up this morning was if someone previously had to sign on to the registry or had a case before of neglect and they got their child back and they were up for another case, would they be able to be eligible for this bill now? So that was something else that we talked about. Also talking about maybe talking to people about drug court and mental health programming to probably add to this and things like that, and educating judges on trauma informed and things like that. So we talked about a few things. And like I said previously, just maybe, I don't know how many sessions we have like this that we can have, or how much time we have left to have more meetings that we could talk about how this can work better for both parties. But we definitely talked about a few things, but I don't know how much time we have to be able to discuss this bill and making it better for everyone.
I don't think we have a whole lot of time. We have a lot of bills in committee. And I think continuing subcommittee meetings for a few months, I think we're going to run out of time with it, but I think we're on the right path. Representative Murphy?
Thank you. I think if it's determined that this bill is necessary, if we need to further clarify what's already in statute, I would be opposed to listing nonviolent offenses as the qualifier, because I think there are things that I just think of many years in child protection, and as moms, whether somebody's going to be incarcerated or not, that doesn't say anything necessarily about their ability to parent, but it doesn't take into consideration things like criminal neglect, exploitation, the vulnerable person as the victim. So, time is one of the challenges. I think that this bill has great merit, but I think that broader approach is a better thing if it's determined that it's necessary. Because I think when we start getting into qualifiers and, we can only prescribe so much what a judge, we have to allow them discretion and again, that goes back to my thoughts about funding the programs and training for judges, so that this is prioritized as a need. But I'm just really want to be really cautious about not further exacerbating adverse childhood experiences for children in an effort to provide a caretaker. And I think you can do that, but I just don't know in the time frame, and I think that's one thing that you guys would have to talk about, and just my input.
Yeah, I agree. I think in order to craft this properly, like you said, without rushing it, without missing something, just in the essence of time here to get this through this session, I think this might be better being worked on with all parties and getting something that's going to work for next, perhaps. Representative Bolden?
It is possible and has been the practice in this committee in years past and other committees in the House to have multiple subcommittee meetings on a bill. As long as they're properly noticed, we can plan several in advance and work offline, or rather just outside of the subcommittee room in between those meetings. So as long as they're properly noticed, we can meet, we can schedule 4 more meetings, and then if we resolve it next time, cancel the rest, and that just would need to be noticed. And but I don't think that 4 more meetings is necessary, because I think I feel confident personally that if I could obtain anything in writing outlining the entirety of what the coalition is seeking for changes to this bill, something that I've repeatedly asked for over 4 months, then it would be, I think, fairly simple, at least for me, with my experience reading legislation and drafting legislation, to be able to incorporate that. And I hope to the greatest extent possible. It's always been my intent to work with the coalition on this and incorporate their views. And in particular, the Tennessee language that we were modeling after, that I guess ended up not being the language, listed certain crimes, and we expanded the list, thereby excluding more people from qualifying for this based on information that ACLU obtained from some public statement the coalition made, I think, on the issue of bail reform. I think that might be it. But the research that the ACLU did is they said, as far as we can tell, the coalition's probably going to want this to not be available to people who've committed these and these and these crimes. And so the list was in the bill is longer than what was originally introduced in Tennessee. So it has been our months-long intent to work with the coalition, and if they wanted to produce any research or any notes, maybe via the text messages that, Pam has my number, or on the Google Doc that I sent her back in September asking for her comments on, or just email me on my available email address, then I could implement that within a couple of days and have it ready for the next subcommittee meeting for all of us to consider.
I appreciate that, Rep. Bolden, and I think, with all due respect, what we've provided in writing in testimony last session and this session is what we are able to provide in terms of flags. I'm myself am not an attorney. My background is in looking at how we can prevent trauma and violence, and I've given all that I can possibly give. I'm happy to continue to connect folks to other entities that we know and work with that could maybe inform, like some of the folks here in the room today, but I don't know what else to provide to inform this process.
Anyone else that wants to speak on this bill? Somebody behind you.
Hi, my name is Griseli. I was here last time to testify. And I just wanted to address to like, the opposition. So I keep hearing that they were saying that this bill isn't really necessary because the judges already have discretion and they can already do these things. But if they were doing these things, then we wouldn't need this bill. This bill wouldn't be necessary. We wouldn't have worked. They wouldn't have worked this time and this hard trying to get this right so that it could pass if it was being done, if it was being implemented. And I also keep hearing something about funding, that we need to get funding, and that they don't have the alternative sentencing, the other, the places where they would get some type of service instead of incarceration. But that shouldn't be something that's preventing from passing this bill, is that they don't have funding for these programs. If anything, then maybe this would give them the push that they need to start funding those programs. But I think it would be a disservice not to put this bill into effect based on there not being enough programs or funding for all these other alternatives that are presented. I keep hearing, and I also, the coalition's concern with the children and someone being returned back into, to possibly harm the dependent and whatnot. That's why we have DCYF. If there's anything that's involving the children that's harmful or has been caused harm to the children by the primary caregiver, then that's going to be presented. That's going to be there, because if there's DCYF involvement, if there's something that has to do with the children, their person got incarcerated, then that's going to be it goes without saying that DCYF is going to be in charge. That's what their job is. Not this bill or not anyone else. So if the concern, like, it's kind of, I don't understand why that would be a concern, because also the same way that they say that the judge has discretion now, he's going to also definitely have discretion when considering this bill and sentencing somebody according to this bill. Because if there is a history, or if there is something that on there, like you said, criminal neglect or whatever, you best believe the prosecutor is going to definitely present that, and then the person's not going to won't be eligible for the bill. but that would be because of that. So we shouldn't not pass the bill because we want to protect the children, because that's what DCYF is for. So if there's something that's involving the children, then they're going to be involved. They get involved when they don't need to be involved. So they're going to definitely be involved if there's something that's going to be of concern, so much concern that they wouldn't be eligible for this bill. So it's almost contradicting to say that the judge has discretion now and he can do all this now, and then in the same sentence say that, but if they have this bill and they have the criminal history, or they did this in the past, or they neglected their children, they might get returned back and abused or whatever. You know what I'm saying? So you can't have it both ways. It's either one way or the other. And as the plea deals, because they brought up the plea deals again, they usually, the judge never really, they rarely don't accept a plea deal. But let's keep in mind that the plea deal is presented by the prosecutor. It's not presented by the people. It's presented by the prosecutor. And the people agree whether they're going to take the deal or not take the deal. So that's not really being worked out. Whether they are primary caregiver or not is, let's just be real. It can be. It's mentioned. I'm sure it's mentioned almost every parent that goes to the court and is a parent and is responsible. I'm almost positive that that's one of the first things that they say. So again, if that was being considered, then we wouldn't be up here presenting this bill, because there wouldn't be so many people who are in jail or in prison for those things instead of alternative sentencing. And then lastly, I wanted to say that ultimately, I know this bill is for the primary caregiver, but ultimately it's for the people it's for the children or the dependents who are affected by the primary caregiver having to be incarcerated or imprisoned. Because if the parent is going to be away from their children for however long, they're the ones, whether they're with DCYF or with family or wherever the case may be. But ultimately, like, if speaking personally, I'm an adult. I'm grown already. If I were to go, to prison, obviously I'm going to be able to handle it a lot better than the children are going to be able to handle it. So they're the ones who are going to ultimately suffer the most, not the person who's being incarcerated. So that's the point of this bill, is to stop that from happening, to interrupt that pattern of parents and children being taken away from their parents, and so on and so forth. And I believe that's all. Thank you.
Thank you. Representative Bolden?
Thanks for calling on me so many times without looking the least bit exasperated. I think probably the Griselli, I think, brings up a good point that in your first comment that really could maybe be phrased more concisely as, like, is this bill going to do something and it'll do bad things, or is this bill already the practice of the court? And so those seem to be mutually exclusive concepts. And I think it's important to get down to the facts of the situation. And I think that we have established at this point that while this is always an option, it's not a directive to the courts. And then there's just the debate over if this was a directive given to the courts, would it make bad things happen? And I think that Griselli even spoke to that, I think, really well, that we already have systems in place to protect people from abusers. I'm not going to say that they're excellent systems, but if the goal of this legislation, as with any legislation, is to solve a problem, then we need to be able to rely on existing systems to address any possible unexpected outlays, because the more specific we get, the more flawed it is, and the broader it is, the more we open ourselves up to unexpected situations. So we have to strike a balance there. And I really think that the one sentence in the Tennessee law could do the deal here.
Okay. Representative Murphy?
Yes. I know we talked about time constraints, and given what we've heard today and at the public hearing, and I think we've all agreed that there's merit to this bill. Sometimes that doesn't happen, and it's easy to ITL. I would support an additional work session. I think we have stakeholders that are willing to be involved. I think that Tennessee bill today, in my mind at least, is a bit more appealing, maybe with some tweaks. I certainly think it deserves consideration and, at least one more subcommittee hearing to see if we could have an amendment. If the prime sponsor could bring forth an amendment in conjunction with the stakeholders that we could agree on. And I would just hate to throw it away because in my mind, it needs a lot of work, but I think limiting things and making it a little bit more general would actually be helpful. And I would support another committee work session.
Representative Tenzar?
I'd just like to add that I concur with Representative Murphy on that.
Representative Bolden? Again.
Or for the first time. Every 7 years, all your cells get replaced. Who knows what happened since I talked last? I might be a different person now. But yeah, I'm reminded of my neighbors across the street. Their grandchildren, their adult son committed some crimes, lost custody of his children. The mother also ended up in prison, and the grandchildren, my neighbors across the street didn't have the opportunity to get their grandchildren, and they've since been adopted out, names changed, no contact. They live somewhere in Florida. And that is what we're talking about with there's a human child, right? Or a human dependent, a person with a severe disability, an elderly parent, someone with dementia, someone with mobility issues who lives in this world now and depends on a person for survival and to have their daily needs met. And the experience of that person either having to figure out how to survive without that person because they've been incarcerated on something that in theory we could address without incarceration if this is narrow enough. So either having to survive without that person, which my mom would not be able to function without me. She doesn't seem to be able to bring her dishes to the kitchen without me. But, or they're going to end up in the care of the state. And when you go to a county nursing home in New Hampshire, or some kind of nursing home, often the arrangement is that your property is signed over to the county, and everything you worked your whole life to pay for, it's not going to go to your heirs, it's going to go to the county for sale. And or they're going to end up in the system with new family, last name changed, and there's all these people in their lives that maybe they could have enjoyed contact with, aunts, uncles, cousins, friends that they were in school with back home in New Hampshire. So those are the lives that we're talking about here. It's not about giving someone, passing the buck on an abuser. It's about someone who's valued and needed by their family, who should have the opportunity to do that self-reforming in an environment that also enables them to keep delivering for the people who depend on them. If I disappeared tomorrow, my family would probably be homeless or have to leave the state within 2 months. I mean, it just wouldn't work. My kid wouldn't be in college. He's over at UNH Durham. That would go down the drain very quickly. There's not enough coffee shops and time in the world for him to work at to be able to stay in school, much less, cover his spending money at record stores. And so these are real lives we're talking about. This isn't theoretical. And I hope that we can focus on the people. And again, with the question of, does this court have this discretion now? In the original public hearing for this bill, we heard written testimony read aloud to the committee from people in New Hampshire who were incarcerated, who had dependents, and what the impact was on the lives of the dependents when those providers, those caregivers were incarcerated. So this is happening. It's not being considered as often as maybe the court should. And I do think that it is really important for the committee to take action in some regard. And I'm more than happy to do all the acrobatics and hard work myself because I gave you this problem and I'll deal with it. But I want to make sure that it's in coordination with all the stakeholders and we get the maximum buy-in and support possible and hear all sides.
Thank you. And just because we heard testimony of people who ultimately were incarcerated doesn't necessarily mean that discretion wasn't used and those things weren't considered. Incarceration was just a decision by the judge. And I don't know the scenarios in those cases, so I can't really comment on the merit of it, but we don't know whether discretion was used or not. So I believe we're in agreement, unless anyone else wants to speak, that we'll have another session. I'll schedule another session and see what we can come back with for language, if it satisfies the group. And we'll go from there. So when are we here next week? I'd like to put it on a day that we're already here. Does that make sense? Rather than come in on a special day or?
The 30th, right?
I think we're only here on Friday next week.
Yeah, I'm looking right now. It's just Friday. And the last bill is 12, so if we schedule it for 1, or I try to schedule it for 1 with Karen and see what we have. Is that enough time to, you think, a week to put together something that you think everybody can work with? Yeah.
If I'm provided the information that all the stakeholders know I've been requesting, I'm sure we can work something out.
And I think the issue with that simpler Tennessee language was the nonviolent part of it. So if we come up with something, we can work on it next week.
Chairman Mannion,
Yes.
1 p.m. doesn't let the committee members do lunch, though. If we have the last bill at 12, then
You are correct. So do people,
look, Tenzar is the
Oh.
perfect example. We need at least an hour for lunch. 2
Right.
p.m. maybe.
What about a brown bag subcommittee meeting? You know, they say we can't eat in this building, but they can't stop all of us.
right. So I guess we can all agree, the 4 of us, so we're going to be adversely affected by it. What do we agree on for a time? 1 o'clock, 2 o'clock? So you want to have a lunch? You want to do 2? Does 2 work? 2 work for, it's Friday night. I mean, I don't know. It's cutting into my sleep time a little bit.
Do you
Getting
know,
close.
isn't the deadline to notify the clerk like 4:30 today or something? Isn't the deadline on Wednesdays to put something in the calendar?
I'll check with, is Karen still here? I'll check with her right now if we can put it in right now for 2 o'clock on Friday. See if that works. All right. Excellent. With that, I will close the session on House Bill 1039.